Okay, welcome back, everyone. Thank you for coming back and joining us for a second presentation around service connection. And we are happy to have Judy Clausen and a couple of her students, I think, who are going to be joining her today. So I will turn it over to Judy now.
Hello, everyone. My name is Judy Clausen, and I am the supervising attorney and professor for UF Law's Veterans Clinic. Okay, so today what we're going to talk about, you've just learned a lot about the law for claims and appeals for veterans, but we're going to talk sort of about the skills, the process, the sort of nuts and bolts. And our clinic is pretty new. We're 2 years old. So we're very sort of young clinic and very excited about this work. And so we've developed a few sort of strategies for these appeals. Mostly our clinic does appeals to the U.S. Court of Appeals for Veterans Claims, but we've also recently taken some of the remands back after we've won a remand back to the board, and we found that work to be really gratifying as well. So we're just going to tell you some of the tricks of the trade that we've developed. We're a young clinic, so I welcome all the very experienced professors and supervising attorneys out there to share their tidbits of advice as well when you see a moment that you'd like to. So first, we work with the Veterans Consortium, and you just saw Samantha Farish from the Veterans Consortium. She's sort of our point of contact and mentor for remands to the Board of Veterans Appeals. So we say we go shopping for a case. We go onto the list of their cases and we look together and we choose about 4 to 5 for the semester, and we work in teams of 3. And so we choose cases at the beginner level, which we find still quite sophisticated and legally and factually interesting. And most of these appeals have been disability compensation appeals. And so that's kind of how we start. After we choose our cases, we request them, and then we do a conflicts check to make sure that there's no conflicts in our office. And then after that time, we offer the client a representation agreement. And as you know, that's a contract. Well, the consortium provides its own representation agreement, and that agreement is great. One of the things that's really important that it does is it addresses attorney's fees and gets the veterans' consent to our recovery of attorney's fees. We think that's really important because we like to use those attorney's fees to help that veteran with the remand if we're able to prevail. Because remands often require working with experts, and that can cost money. We also offer our own representation agreement, and in that representation agreement, we make it clear that students are going to be working with the veteran. And so then when we offer that representation agreement to the veteran, we talk to the veteran about the representation agreement, and we explain in a conference call exactly how the representation is going to look so that the veteran understands the road ahead. And we just sort of tell the veteran we're happy to talk to him at any time we have any questions, that we won't file anything in the court without first showing it to him. And we tell him what to predict in the process, what our sort of goals are going to be, and we ask him what his goals are. And so that's sort of where we start. At that time, we also interview the veteran. And at the end of the presentation, I'm going to invite my students to tell some of their experiences and some of their tips. But we find that client interview to be really valuable. The record is set on appeal, so it's not like you're able to add any evidence to the record from that interview. So the veteran will sometimes tell you some great facts that you would love if they were in the record. But if the record doesn't have those facts, you can't supplement the record. But sometimes that conversation with the veteran helps you understand the record a lot better. Okay, so after that initial client interview and after we've executed the representation agreement, we start with our review of the record before the agency. And we do this in sort of 2 cycles. In our first cycle, we're just determining whether the record is complete and legible. And so Our mentor at the consortium, the Veterans Consortium, sort of taught us how to do this, and the method works really well. We read carefully the board decision and the decisional documents from the file, and we list all of the important things that we want to find in the record. So that will be all of the decisions that VA has made, all of the evidence that was referenced in the board decision, like expert evidence and lay evidence. That might be key medical records that were mentioned in the board decision. That might be the compensation and pension exam. Of course, the DD-214, the veteran's exit document when he left service. And so we list all the things that we want to find in our Easter egg hunt. I heard one of my colleagues in the consortium refer to this process as an Easter egg hunt, and it kind of is that. And so we make a sort of roadmap of what we're looking for, because this is our only opportunity to, I say, gripe in case the record is incomplete or illegible. I'll have you note that one time we had another veteran's record in the record. We started reading through, and this veteran looked like he had completely different health conditions and a lot less severe PTSD, and we realized, oh, he had a different name. So that can happen. You really want to make sure that all the dates are correct, that all the page numbers are there, and that you have a complete RBA. So that's our first review. When we do this review, we make a document log, and we want to show the title of the document that we're referencing and that we found, the starting page number in the RBA, and the ending page number in the RBA. Okay, then after that point, we have this certain time frame in which we can dispute the RBA. And if we need more time, we request an extension because we want to dispute before that time frame elapses. And so we have requested extensions before, depending on when we take the case. Sometimes we only have a narrow window to do that first review. And so then once that time passes, it's much more difficult to gripe about the RBA being illegible or incomplete. In our second review, I think I heard one of my colleagues say this is when you become an investigator. This second review is where I think the students should be looking to search for evidence to support their arguments as they're reading, and search for the story as they're reading. And so in this second review, you're reviewing the record like an investigator. And so you should really be taking notes. And we feel that the way to write a really impactful conference memo is to quote heavily from the record and to cite heavily to the record your evidence. So make quotes when you do the second substantive review. You don't know what you're looking for unless you first understand what the arguments are, what the claims are, what the substance is. So before we do the second substantive review, we read the board decision many, many times. The board decision will refer to primary sources, and we'll go look them up. And those primary sources will be the applicable regulation, the applicable statutes, and the applicable cases. And so we'll read all of those before we do our second substantive review, so we can really understand what this claim is about. We also always work with the consortium because we're a new clinic. We have never taken an appeal without the help of the consortium yet. But the consortium is really generous and gives us a screening memo from a veteran's lawyer who really knows what she's doing and does this stuff full time. And this screening memo will identify 1 to 2 issues that are worthy of appeal. And that helps us get started to think about what are going to be our arguments in our conference memo. Okay, and so then I keep referring to this conference memo. One thing that you should become friends with is the U.S. Court of Appeals website. That website is so invaluable to you because you can do a docket search by checking the status of your case, and so you can see all the key dates. Of course, you'd want to, as a clinic, calendar all those dates so you don't miss any deadlines, but we're repeatedly checking, doing a docket search. I also will often ask my students, you know, let's say that we're writing an attorney's fees petition. I'll say, well, in these 5 cases, these 5 first and last names, we've filed them successfully. Go look at those samples, and they'll show you the general structure. So the court website is invaluable for that reason. It's also invaluable because all of the court's rules of procedure are there, very easily accessible to you. And so everything with deadlines and the type of font, 13-point font, the page numbers, what needs to be that you're allowed in a specific brief or memo, how you do a motion, all of that is set forth in the rules. And so you should repeatedly be going back to the rules and looking for the rule governing the document that you're preparing. So the first document that we prepare is the conference memo. And this is what I came from a commercial litigation background. I think of this as sort of a mediation statement. It's a 10-page document in which we are highlighting our sort of key arguments, and we're sending this to the central legal staff of the court, as well as the opposing counsel at the VA General Counsel's office. And so this document is our document that sort of shapes the staff conference. This is under Rule 33, in which we meet with a representative from the court, central legal staff, and the opposing counsel. And we talk about whether or not we can resolve this now favorably without going to full brief. And usually what happens after this settlement conference, oftentimes what we're seeking is a remand to the board and the VA General Counsel to say, yes, we recognize your arguments, we agree with one or more of them, and we will agree to a remand. And that's usually what we're seeking. The reason we're seeking that is because to get a full reversal is very, very difficult, because at the appellate level, the fact finder is below. And so to reverse a finding of fact, that's a clearly erroneous standard, and so that's very difficult to prevail on. So really what we're often left with and what we're seeking and what we consider a win is a remand. And I'll show you some typical reasons or problems in a board decision that warrant a remand. Okay, so when you write this 10-page memo, and now we've written quite a few, and I think we've gotten pretty good at it and better at it, you're identifying all the errors that you see in the board decision. So one thing that we've found very helpful, aside from the screening memo that comes from the consortium, is that we carefully review a key chapter in the Veterans Benefits Manual that lists all of the common errors in board decisions. And it seems that board decisions frequently have a few key errors. And so when we do that second substantive review, we go and look for those errors. And those errors might be things like a failure to adequately explain themselves. That's the adequate basis and reasons argument. And that means that the board decision decides without adequately explaining itself. And so that's an argument, and that's a problem with the board decision that we often see. We often see also a reliance on an inadequate medical exam, or that the VA failed to meet its duty to assist. So you'll see, if you review, I think I have it in these slides, the chapter that just sort of outlines the 6 or 7 common problems in board decisions. We find that very helpful to understand those problems and then to go look for them. Okay, when you've prepared the way we write the conference memo, and I'm a writing professor by background, the way we write the conference memo is the students write it, and I usually divide the students by argument. So we often have maybe 3 to 4 point headings, 3 to 4 arguments we're highlighting. Each of those arguments is an error in the board opinion. And so individual students will own an individual argument. And the way we write the argument is CREAC. So we start with a point heading, an argumentative point heading that succinctly states what the problem with the board decision was, and therefore what that warrants, usually remand. And then the student will kind of explain the relevant law and apply the relevant law. And often I find that when the students finish their conference memo, it's about 15 pages, and I'm okay with that, because I want the students to sort of expand and explore and really work with the evidence and do everything they need to do. And then at the end, we streamline and we fit it within the 10 pages, and that in itself is an art. Sort of crunching it down. What we found in the crunching it down process is that we often streamline our explanation of the law and really focus on our application of the law. And we theorize that we're writing to an audience that understands the law, so they don't really need this huge explanation of the law that you learn to do in legal writing, given that we have these space constraints. And instead, in our application of the law, we're really clear how the law is mandating our argument. And the way we do that is every sentence in our application, we cite to the record, we quote from the record, and we cite to the applicable case. And often we have a parenthetical to about the key language from the applicable case where the rule comes from that we're applying, or to the applicable regulation. And it was our first mentor in our first case that told us you really need to cite to the law in your application section. And I had taught legal writing for years, and my book never required that. And so that was sort of new for me, but I have found that that is really the way. I think that citation to the law in the application section really shows to the reader exactly how the law is mandating the argument that you're making. Okay. Now, when we submit the conference memo, it's kind of interesting the way you do it. It's 2 weeks before the conference, 14 days before the conference. It's not filed with the court. It is this confidential mediation statement. So it's sent by email or facsimile to the VA General Counsel's office rep, the opposing attorney, as well as the assigned central legal staff attorney. And to the conference memo, you will attach what we call the RBA excerpts. So what this means is you go to, let's say you have a 4,000-page record before the agency, which is the veteran's entire claims file. You will only be citing maybe 50 pages of that huge RBA in your conference memo. Those are the RBA excerpts. And then we make a sort of little packet PDF of the RBA excerpts, and we sanitize them to remove the veteran's Social Security numbers. And that way, the central legal staff of the court and the VA General Counsel can easily see the record evidence that you're citing. And so one thing I tell my students all the time, because often I have second-year students and they're so used to learning law and talking about law and summarizing law, but this is all about the facts to me, at least. I think the facts are super important. And so even though it might be annoying to read 4,000 pages, reading carefully and really thinking about the facts and really thinking about what happens is the key to writing a successful conference memo. Another thing that we've instituted recently is to make every team write a statement of the facts, even though they won't have it in the conference memo because there's no space, but it helps the team understand the story. Sometimes these stories can be quite convoluted. And so just writing the statement of the facts, that helps everyone who's writing about the case really understand what happened. Okay. Now, then we have the settlement conference. And this is quite exciting. It usually doesn't last very long. And in my clinic, the students audit the settlement conference, and the VA General Counsel's office and the court central legal staff has always been very generous and allowed the whole team to audit, which has been wonderful. And afterwards, we talk about the process. I find that it's really important to review carefully before the settlement conference, because it's easy when you're working a lot of cases to forget about the nuances of each case. So what we do before the settlement conference is we review our memo, we review all of the cited sources in our memo, we review the screening memo that we got from the consortium, and we review all of our cited portions of the RBA, because we want to be ready to go and sort of like very prepared in case something unexpected happens in the settlement conference. And that has happened. That we have been able to, we've had the VA General Counsel start the settlement conference saying, we're going to defend, we don't accept your arguments, they were well crafted, but we're going to defend. And we have then sort of orally restated our arguments and had a conversation and actually convinced the VA to agree to a remand. So that settlement conference can be a real important event outside of the memo itself. And so at the settlement conference, basically it'll be telephonic. We've been told never by Zoom, it's not visual. The central legal staff attorney will introduce herself, and then usually the VA will start with their thoughts about your arguments and where their position is. And then that's your time to respond, ask any questions if you need clarification. Make sure you listen really carefully to what they've said. And then at the end of the settlement conference, we found that in most instances, we've convinced VA to remand, which we're really excited about. If you read the Veterans Benefits Manual, though, you do learn that ultimately most of these cases are remanded. But it's nice when it can happen at the settlement conference. And so I think in all of our cases so far in the 2 years, we've only had 2 go to full brief, so that we were not able to successfully negotiate the remand. So basically, if you do successfully negotiate the remedy your veteran seeks, I go to the settlement conference armed with the ability to agree on the spot. But I find that unless the VA General Counsel, that means that I've talked to the veteran first, and the veteran has said, yes, I've read the conference memo, and if they agree to what we're seeking, I understand what we're seeking. If they agree, I authorize you to agree to the remand on the spot. You don't have to come to me. But if there's any subtle difference, I say, even if I think the veteran will agree, I say I need to go back to the veteran because I'd like to talk to the veteran. And sometimes I just feel like I want to be overly cautious, and even if there's no difference at all, I say, let me just go back to the veteran and make sure the veteran agrees. So go back to the veteran and we really discuss with the veteran what this means, what will be the process. I tell the veteran what I would recommend, and then we contact the VA, and we usually agree to what the remand offer that the VA has given. And then after that time, and so I've kind of gotten ahead of myself with my PowerPoints. At that time, at the end of the settlement conference, you're going to go down one road or the other. Okay, so the one road that seems to be the more frequently traveled in our clinic is to get the VA, elicit the remand offer from the VA, tentatively agree in concept, and then the VA will give us a joint motion for remand, and we will help tweak the language, and then the matter will be remanded to the board. But the other path is when the VA says, nice arguments, impressive students, your students wrote a brilliant memo, but we're going to defend. And if that is the case, often the VA General Counsel will say to us, but if you think of more arguments, you see something new in the record, we're open to hear new arguments. And we've had the VA generously say that to us several times. But so in this second road, then now you're going to full brief, and that first brief will be the veterans. So now we're taking the different pathways. At this point, I might want to ask Jackie, if you're online, Jackie Carreau, my former student and intern and now TA, if you'd want to talk any about your experience writing conference memos.
Hi everybody, my name is Jackie. Like the professor said, I've been with the clinic a long time, apparently worn quite a few hats. I've been with the clinic basically since it started. So I love conference memos. They are my favorite, and hopefully me and the other 2 students, or I and the other 2 students can kind of just give the student Cliff Notes version of everything that you've just been told, because you have just been bombarded with 2.5 hours of very dense material. So hopefully we can kind of just give you the students like version of it. And then once you get into it, I promise once you get your first client, everything kind of starts making sense. But so conference memos are my favorite, mainly because they're super limited and they're a very narrow topic. So you're basically just looking at what the board did wrong and why either you need to start from scratch, which is ideal because then they're basically like, yeah, we totally screwed this up. Like, let's try again. Or they're like, we still think we're right, but you can give us a much longer paper and we'll talk about it. So remand's ideal, but you basically just go through and you find all the holes for the board, which honestly, when you're getting records that are like 800, 1,000, 2,000 pages, like there's a lot of room for the board to miss things. So there's ample opportunity to show things that they might have missed. So quickly, just the process, and the professor went over the process, but for me, and I don't know if I can, I can't really speak to other schools, but I know at UF, students are not used to getting evidence and then having to write memos. It's usually in law school, it's all about case law, and like you'll get a topic and you have to research all the cases and you shepherdise and you do all that cool stuff and you write a memo. It is very different and sometimes very overwhelming when you get a massive RBA and it's just like 3,000 pages of medical documents and you kind of just want to like, you remember why you didn't go to med school. But so it can be very overwhelming. Your best friends are the court or the opinion that you're given. And if you are lucky enough to work with the consortium, because they're amazing, they give you that screening memo that is the most just ideal jumping point when you're going into the record and trying to find those little like Easter eggs, if you will. But so if you get overwhelmed, that's totally normal. These documents are massive, but really start with everything that's already been given to you and then kind of go in and just find the things that fit your arguments and any other arguments that you might be able to make. Not every argument's going to be a winner, but that's for the professor to cut out later. So that's just the general like process. The biggest thing as far as writing a conference memo is it is so unlike anything you've written before. Like what we learn in law school is not what we do in practice. We learn nothing about being actual lawyers, especially with the VA, because they have very particular ways and things that they want to see, especially when it's only 10 pages. And oh, by the way, 13-point font, it's like 5 words a page. So you got to be really clear and concise. Make your argument. It's kind of get in, get out, and be good. So make your argument, cite the case that the rule comes from. Do not go into a case brief because that's a waste of time. Just, really drill the point home and then move on, which is amazing because you don't have to case brief, which I don't know about any other students, but like my least favorite part. But yeah, also you're really focused on the record. At this point, the board has had the record. It was their responsibility to review the entire record and to give the veteran the highest rating they possibly can and the highest rating they deserve. So you're going through the record and you're citing all the things that they didn't talk about that they were supposed to talk about and the reasons that they need to go back and look at it again because your guy totally has TDIU and can never work again, and the $2,000 that he gets a year is not sufficient. So it's a pretty good, easy argument. I like it. Again, no outside information, which is hard because you kind of get rolling and you're like, yeah, and then we can argue this, and that's not your job at this point. Do that on the remand. Now you're, you got your little blinders on and you're focused. The other thing that I kind of just wanted to say is like students' tools and tips and tricks in like your toolbox. There are certain things that are just absolutely amazing, and I am not trying to kiss anybody's butt right now, but Montana's CLE series is a godsend. I think I have seen every video like 3 or 4 times. You can get the transcripts, you can watch them over and over. Like I speed it up, I slow it down, I write notes. I've watched them all a million times. They're amazing. But also there are law firms that post videos that are like specifically for veterans. Watch them, YouTube, lose yourself a little bit and just kind of try to learn from every possible way. Once you're in it and you're actually working on a case and you're looking for certain information, the CLEs make a lot more sense. If you just sit down and you're like, this looks like a fun 2-hour movie, it's not. Don't do that. Go in with something that you're trying to get out of it. Also, the VA manual is incredible. If you're on Lexis, I know the whole thing is there. It's probably on Westlaw. It is written in normal English speak. It explains things to people who are not veterans, who are not military, who have never even, you could never even watch Saving Private Ryan and understand this VA manual because it's so good and it links everything. So start with the VA manual. It's super helpful. Also, CFR is life. If you guys don't know anything about the VA and military and everything comes down to the codes. So a lot of people are asking questions about certain disabilities and how do you argue this and what is this? The code will tell you everything. Whether or not you agree with the code, not really our job, but the code is everything. So we have one case where it is like an eye condition. The rating is literally based on how many times he went to see his doctor for this eye condition in the last 6 months. Whether or not that's a valid argument or analysis or measurement, not for us to decide, but like it definitely narrows down what you're looking for in the record when you know that that's really all you have to prove. So keep the CFR on your, bookmarks on your Chrome or whatever you use, because it'll be your best friend. The consortium is an amazing, amazing, amazing resource. I have never seen an area of law where people are so willing to help each other. Like you could literally reach out to just about anybody and be like, hey, I have a question. Very few people are going to tell you no. It's amazing. We ask people all the time. Like we go to Stetson all the time for questions and things we haven't seen. Amazing people. Never, be scared to ask a question if you need it. Also, you can call the VA. Surprisingly helpful. Not like the DMV where like you're on hold for 5 hours and then, they hang up. The VA is super helpful. If you go in and you're like, hey, what's the code for this? They will give you the answer and help you figure out like what forms do I have to file for this? And, what should this be? And what should this look like? They are super helpful. Call the VA. Finally, my favorite thing is conference calls with the client. What this does for us is it just builds the story around that entire document that you've got. If you've ever, everybody's been to the doctor, but if you've ever noticed the notes that the doctors are taking are like 2 words, it's not going to get published in any journal. Like they're not helpful. They're not even really like complete sentences most of the time. Trying to find information in those records is super hard. But when you talk to your client and they're like, yeah, so it looks like asthma, but in actuality, I was outside in the middle of a snowstorm with no gear for 24 hours and couldn't sleep. And then I got pneumonia. And that's actually what happened. Like, it's super helpful, absolutely necessary to understand what you're actually dealing with. And understanding the military. I grew up in a military family, so I feel like I have a little bit of a benefit. So if you don't know about the military, you're not from it, you're not around it, do your research. If you have a client that was in the Gulf War, and let's say they're coming back and they're trying to claim MUSCI and they're like Gulf War syndrome, which, oh, by the way, is a total dumpster fire. But anyway, if they come back, if you don't know that there were oil fires or that they spray the sand with oil or that, all these environmental factors, you're not going to be a very good advocate for your client when it comes to getting all these claims. So do your research, learn about the area, learn about your clients, learn about the things that happen to them, really dig in. The most important stories are the stories that they're not going to tell you because PTSD is real. It's also things that they don't know were really a problem. Like, we talked earlier about certain people not claiming PTSD because of the stigma, which is totally a thing. But a lot of people don't even realize that they had it, but they'll be like, yeah, I haven't slept in 2 weeks and I, jump every time fireworks go off. That's normal, right? Like, not so much. So listen, help, be there, and just learn. But when it comes to conference memos, which I realize I totally derailed from, it's super narrow, be super specific, forget everything you learned in law school and use all the resources you have available. And I think I talked too much. So thank you, Professor.
I think you were amazing. Thank you, Jackie. I'm so excited you're my TA. So let's go back to so one thing that Jackie said that I want to follow up on is she talked a little bit about how to find the Easter eggs. And I thought of one example that we had, our very first case, which still is our favorite. I think we'll always be friends with this veteran. He was a Vietnam veteran who had the horrible experience that you were told about earlier, really traumatic events. And he didn't file a claim for disability compensation until years after service, after he had suffered a really hard life, including homelessness and all sorts of problems. And then when he was first granted service connection, it was at kind of a low level for PTSD. And then it had eked up through a couple of appeals, but he was still way below where he needed to be. So our first appeal was reviewing this board decision that had him disabled at 50% early after he had filed the claim, which made no sense. And then 70%, because that was really close to the event or closer to the event, and then 70% later. And what we did is exactly what Jackie said. We took the rating schedule for PTSD and we looked at the symptoms at 100%, at 70%, and we listed them and we made a grid, and then we went back and we looked for that. And it was actually not boring at all, because when you see, you know, let's say the symptom is hallucinations or suicidal ideation, and then you go back through a whole 4,000-page RBA, and you see his therapy notes, and you see his statement, and you see his ex-wife's statement, and you see some things that had happened in his life, you can see that all those 100% symptoms were there, and that the board failed to see them. And so that's what I mean by that second review needs to be like an investigator. You have to go back looking strategically. Okay, so thank you, Jackie. Now we're going to move on to the one path, which is the joint motion for remand. So the first thing I would say is that Veterans Benefits Manual is amazing, and you always go back to it. So before you're doing anything, go read the relevant chapter. So if you have an appeal that deals with hearing, lots of appeals, by the way, deal with hearing, either tinnitus or hearing loss. That's a common disability people get from service because of all the loud noises, okay? So go look in the index of the Veterans Benefits Manual and go look at the hearing section. Jackie mentioned TDIU, which means that someone, even if they don't qualify at the total disability rating based on their symptoms manifestation is such that they cannot work. And so they have total disability based on individual unemployability. Well, there's a whole regulation about that and lots of case law about that. There's a framework there. So before you go back and do the Easter egg hunt, you have to understand the framework and know what it is that you're looking for. And that's what Jackie was saying. So when she had a TDIU appeal, and what happened in that instance is the board failed to recognize that our veteran couldn't work because of his symptoms, then Jackie had to understand what TDIU was before she went back through the appeal and looked for evidence of his inability to work, and the record was actually fraught with that evidence. And so that's what you do when you do the strategic look. Okay, so now we're going down the first road, which is the joint motion for remand. So in recap, what's happened now is you have succeeded at the settlement conference. The VA has said, oh, your students are brilliant writers, and now we agree with your arguments, and now we're going to agree to the remand. Then what happens usually is that the VA drafts up the first joint motion. Okay, so you're asked to then join that motion. What's in that motion is super, super important. Go read the Veterans Benefits chapter about what needs to be in it, okay? You want to have all of the things that you've agreed on. It needs to be really clear and precise. And the reason is because that motion then becomes the remand order of the court. And so it goes back to the board. And now the veteran has a second opportunity, and the board has to follow the order. So you need to have everything you want in the joint motion in the joint motion. We have learned, and maybe there'll be other speakers who have talked about this, but we've learned from our mentor that under the Modernization Act, that you might find that VA will give you pushback on putting the key language in your joint motion that the veteran is free to offer further argument and evidence when he goes back on remand. And that is really important to have that language in there. And let me explain why. The remand is the second try. And so if the veteran cannot then offer his statement to clarify, offer his wife's statement to clarify, if we can't retain an expert to say, yes, this did happen in service, if we can't do all this, if he can't show his new medical records, if we can't submit a brief clarifying our arguments, if we can't do any of this, the remand's meaningless. So the remand order has to say that the veteran is free to offer further argument and evidence on remand. And so that's one thing that we've been told we've never had pushback, but we've only had one appeal under the Modernization Act. And in that instance, the first version of the JMR did not have that language. And I immediately called our mentor and said, oh no, it's happened. We heard it would happen and now it's happened. And so we wanted the language, and the VA General Counsel agreed. So it was fine then, but it's something you really have to be careful, because when you get the joint motion for remand proposed, you feel like you've won, but really what's in the wording of that motion is really, really important. And there's other issues that need to be addressed in that motion. They're all outlined in the book, but that's the one key one that I really wanted to highlight. The veteran, it needs to make it clear that the veteran can offer further argument and evidence on remand. Otherwise, the remand's not meaningful. It's no victory at all. Okay, for some reason, it's not going forward. Let's see, here we go. Okay. Okay, so then what happens is that once you've agreed, then the joint motion is filed, that becomes the order of the court, and then it's remanded. And we're gonna talk about remand representation at the end. Let's talk a little bit about attorney's fees. Okay, so there's a whole chapter in the Veterans Benefits Manual about the EJA fees, right? And so EJA fees are fees that you have available when you prevail in an action against the government. And there is a framework, and you have to brief the issue, and you have to, one of the specific things that's really important that you have to do is show all of your hours worked, and all of the descriptions of your work has to be very, very specific. So at the beginning of every semester, and I recommend this to you all, please read the chapter in the Veterans Benefits Manual about the Equal Access to Justice Act fees and the recovery of those fees, so that you understand from the outset when you start to log hours working on these appeals how specific that you need to be. Now, I tell my students, do not shave off any of your hours, write them all down. If you're working on the case, you're working on the case. But you need to be specific. So if you're reviewing the first 200 pages of the record before the agency, say the page numbers. If you're researching in connection with one specific argument concerning one specific board error, be that specific when you log your hours. Another thing is that the VA will look down on block billing. So you don't want to bill like 8 hours of time. You want to have it be 3 hours or less. So you want to work in very focused chunks, and not block bill so that you block like 12 hours working on something. You want to work in focused 3 hour or less chunks. Now, then once I collect all of the work logs, I then streamline them, because you are required under the law to, you know, be efficient, and to own, we usually cut off 2/3 of our hours, if not more, and you're required to be efficient. So I want to just mention attorney's fees, because it's not generally all that important to the client, but it is if you're going to take the remand, because I feel like these are the fees that are then our funds, our pot of funds that we can use to help this veteran on remand. Okay, so now let's talk a little bit, because I see I've got about 10 more minutes, about the briefing process. We've been through this twice now, each time very exciting. So it's a really unique opportunity for law students to be filing or writing briefs that are filed in federal court. It's huge, and these are all really important cases to our clients' lives. So I'm thrilled to be a part of offering this opportunity to students. I think it's amazing. There are rules about what sections are in the brief, and here your appellate advocacy class is just very helpful, because these briefs are very, very similar to, you know, the briefs in federal court. So we have our table of contents, our table of authorities. Of course, there are rules about timing, of course, and your supervising attorney will be working with you on this. I'm not going to go through the specific days and all that, but you always want to be very mindful of deadlines. We're talking about federal court deadlines. The court is relatively generous about granting extensions, but it's best to request the extension early on and to show your good cause. And we often argue, we are a law school clinic. We've been arguing we're a new law school clinic. And so, you know, when we just transitioned our student team, but we always request, if we need the extension, we err on the side of requesting it. And when you request it, you request for the full amount of days. That just makes it logistically easier for the court for calendaring. So, you know, go back to your appellate advocacy classes, because a lot of the same advice is there. When writing issue statements, if you can remember how to do that, tee up your issue statements so that they can be answered in your client's favor. Make an issue statement for each of your arguments on appeal. When you have your statement of the case, a part of that is the statement of facts. Go back to your appellate advocacy class. Do you remember how important the statement of facts is? To me, it's the most important part of the brief. And your statement of facts is all going to be record citations, quoting from the record. You don't argue in the statement of facts, but you state it persuasively, which means you hide the bad facts in the middle and you put the good facts at the beginning of the paragraph. You state it chronologically. You tell the story persuasively, but you do not argue, right? And remember that you have to deal with adverse facts as well. All of the advice you got in appellate advocacy applies for this. Now, when it comes to the summary of the argument, again, back to app-ad, you're not citing in the summary of the argument. We write that section last. We write that section after the argument section is completed, and then writing that section helps us refine the argument section. When you get to the argument section, again, your persuasive point headings, you want to make every single argument, you want to preserve every single argument because you don't want to lose the ability to access an argument later on, right? So you want to make every single argument available to you. If you read the advice in the benefits manual, it says that if you are making arguments that warrant reversal, you should start with those even if they are weaker, and then make the arguments that merit remand, right? Those are different types of relief. In the argument section, again, remember the key to effective argumentation is to really work with the record. So you want to quote from the record, you want to quote from the legal standard, and you want citation after every sentence, okay? Now, when you write your brief, and this you should sort of plan for in advance, the citation is interesting. It's sort of simple, but it's interesting. You're going to be citing to, let's say you're citing a medical opinion that's on page 50 of the record before the agency. So you would say, you know, R50, and then you would have open paren, and then let's say that medical opinion is from page 45 to 52, you would say 45 to 52. So in your brief, you're clear not only the page of the RBA you're citing to, but the actual total document you're citing to. And then the citation in those parentheses, those are the total documents listed in your table of authorities as the record citation. So your table of authorities has all of your cases in alphabetical order and the page numbers they are on, all of your statutes, all of your regs, and all of your record citations. And it's at this point, and it's better to do it early on, that you figure out that, you know, each of these parts of the claims file, each of these parts of the huge file is a document with a name that has a beginning page number and an ending page number. And then, of course, you complete your brief. You conclude your brief with a conclusion section. You want to. That's usually short. You state the relief sought. Now, one issue I'd like to touch on that I think has been briefly mentioned before is that when you start looking through your cases for your analogies, let's say you have a hearing loss appeal and you found a great similar case in which the similar hearing loss case, the court gave the remedy that you seek in your case, so you want to create an analogy, and you learn that that case was issued by a single judge instead of a panel and is therefore an unpublished opinion. So you can cite those opinions in your brief. Now, I've heard from mentors that we shouldn't, but if you look to the rule you are allowed to, it's Rule 30, but there's specific requirements for citing unpublished opinions, and that you really basically, you are only citing them because there's nothing else in place, and you have to show exactly how the reasoning applies to the case. So you should reference Rule 30, and you should go try to find a panel case that is persuasive, that is authoritative first. So I don't preclude the students from using unpublished opinions, but I always urge them to go find the published opinions first. And you know, we have written briefs that use these single judge opinions, but again, look to Rule 30. There are rules about doing so. Okay, we just wrote our first 2 reply briefs, and boy, were they fun. So we filed the initial brief, then we get the opposing brief from VA, and this was super fun, the reply brief. And so this was our first reply brief. Basically, the key things I would say with the reply brief is that it's going to be shorter. It's 15 pages or less, and that you don't want to just rehash your arguments from your initial brief. You want to address arguments made by the opposition. And we looked up some guidance just generally on writing reply briefs, and it was very helpful. So one thing is look for concessions. Did the VA concede some things? If so, make a point of it. Look for omissions. Did the VA not address your best argument? Well, that silence tells you something. So you should make something of that in your opposition brief. Did the VA misconstrue a case? Is there a different way to see it? Well, you should explore that. Did the VA use hyperbole and kind of overstate things? If so, go address that. For instance, in our reply brief, there was a serious factual error in the board decision, and the VA started calling it a typo. Well, that presumed that the board understood what was going on and just made a typo, but the record really didn't support that. So because the VA's opinion had said typo, we used typo like 30 times in our reply brief. We felt like that was an effective way to really argue with the reply brief. Now, I have two students I would like to be able to talk, and because they have some good stuff to share. Elizabeth, you were going to share a little bit of your experience with reply briefs.
Hi, can you hear me?
We can hear you.
Hi, okay, great. Hi. Sorry, I'm currently remote right now, so I'm in a corner, so I just want to make sure you guys can hear me all right. I obviously by no means am an expert. Professor Clausen is phenomenal, and I say she's like an encyclopedia of knowledge. And so this is being my first summer and my first ever experience with the Veterans and Service Members Clinic. I don't know a whole lot, and this is my first time writing a reply brief, but the experience was, like Professor Clausen said, it was incredible. And from my perspective, the tips and tricks that a lot of people have already said remain fairly consistent. Know what you're good at, know what you're bad at, know your client, fiercely advocate for them. And it sounds kind of silly, but how Professor Clausen was saying to dissect all the arguments and the language that they're using, things that they're omitting. I found it helpful to find a sense of connection to the veteran themselves that motivated me to feel like I was fighting for the ultimate goal and stay connected to the bigger picture. Because sometimes if you're, as we all know, you can get lost in the weeds of law very easily. And it can be difficult at times to maintain perspective of, oh, I'm fighting for a human being. I'm fighting for their rights to something that they deserve, something that they have a right to. And so maintaining that perspective in the reply brief specifically was helpful because, as Professor Clausen said, you cannot come up with new arguments. And the only other thing I would say that I found helpful, because as a student, I think it's natural for us to question if we're right about something, because we all know every time we learn something, we realize we don't know anything. And it kind of instills that further and further the more that we learn. And especially as first years, it can be difficult for us to trust our gut instinct. But I would say, at this stage, trust. You do go to law school, you are studying the law. And if you have a feeling about something and you're worried that you might look silly or look like you've made a mistake or misunderstood the law, I say it's worth it to take the risk, work with your professor, work with your mentor, and see how it plays out, and trust that gut instinct that's tied to fighting for the best outcome for your veteran and for your client. So I think that would be my quick tips and tricks and what I've learned from this experience.
Thank you so much. So the last thing, I think I don't have a lot of time now. So I'd just like, if Stephanie is on, the last thing I'd like to say before Stephanie comes on is I want to make a real plug for taking the remand. We have taken one and we won $250,000 for the veteran, and we were thrilled. So the success that you have when you get a remand it's legal and lawyers love it, but it's not as real to the veteran as when the veteran actually wins from the fact finder. And so I would really support taking the remand. The key things that happen on remand is that at that point you hire experts and you help those experts make evidence. You go back to the veteran and his family or her family, and you help them make lay evidence to support. And then you pivot with your brief. You're now arguing directly to the fact finder. Instead of citing cases, you cite the regs, and you make the brief short, 10 pages or less, and now you're just making arguments for the veteran to win. It's not about whether the board erred. And so Stephanie is, if she's on, I'd love for her to talk about helping a veteran prepare lay statements, because she's been doing some of this in connection with actually a discharge upgrade, but there was a character of discharge PTSD claim involved as well. So it does involve disability compensation. So Stephanie, if you're on. I'm assuming Stephanie's not on. Okay, so that said, then we have 5 minutes left if anyone has questions.
There are questions, Judy. Thank you.
Okay.
We have a few questions for you. The first is, how do you help students get through a huge record and not be overwhelmed? How do you help them eat the elephant, so to speak?
Oh, yes. That was your article when you talked about eating the elephant, right? You know, hopefully I do it successfully. If someone told me, one of my colleagues has done a lot of work with the consortium, and I might try her advice. What she does is she reorganizes the RBA. So she reorganizes it into the VA decisional documents, the private records, the VA private health records, the VA records, and the lay and expert evidence. We don't do that. What we do is I tell the students, relax on your first read. All you're doing is determining whether it's legible and complete, and you're trying to figure it out. I assign the chapter about the claims file so that they can understand what they see, and we talk about what you're generally going to see. You're generally going to see the compensation and pension exam. You're going to see private healthcare records. You're going to see VA healthcare records. You're going to see decisional documents. We talk about what those are. And so generally just kind of knowing what you're looking for. And basically you swim with the thing long enough that it's scary at first, but after a while it becomes something you kind of know like the back of your hand.
Right.
My team, yeah, that's what I do.
Can you also, for students who are not very familiar with CAVC decisions, can you help them understand the difference between published and unpublished?
Yes. So the unpublished ones are done by a single judge, and they don't have precedential value. But if you look to Rule 30A, I believe, you can still cite them, but there are requirements for citing them. And so sometimes they're the best ones because the court often rules with single judge decisions. So there's a lot of them out there. And some of the most exciting ones that we wanted in our brief were these unpublished decisions. Rule 30A says you can cite these actions that are non-precedential only for the persuasive value of their logic and reasoning, provided that the party states that no clear precedent exists on point and that the party includes a discussion of the reasoning as applied to the instant case. And so what we usually do is really look for published decisions that have the point that we're looking for. And we start with those. But if we get within Rule 30 and we still need to cite this unpublished case, we will drop a footnote explaining, addressing why we can cite it under Rule 30. So the difference is between a panel decision, which has precedential value, and an unpublished decision by a single judge. And the problem is some of the unpublished decisions are great and really favorable, and it's hard to ignore them. So you don't have to completely ignore them.
And then I think we have 1 more minute. So can you describe your philosophy or what you think the best practice is in terms of actually drafting the joint motion for remand? Do you rely on the Office of General Counsel, or do you take the first swipe at it?
It probably is better practice to take the first swipe, and I haven't done that. It's always been the VA General Counsel, and then we carefully look over it. And we're a new clinic, so I have never let one of those go without also talking to my mentor. And then I felt that the chapter and the guidance and the heads up, frankly, from the consortium to be on the lookout for the elimination of this sort of right for the veteran to offer new argument and evidence. That's been a very important thing. But I just read carefully to make sure that everything we've agreed on and everything that we insisted is there. I mean, there's other things you want in the joint motion. You want to clarify the things that were favorably decided and that those are not going to get uprooted. So you want that in there too. Because there's often a veteran has many, many claims, and the appeal and the whole discussion is focused on a few, but some the board favorably decided. So you want to make sure that the board doesn't go and mess up those that were already favorable for the veteran. You also want to state that the board should handle it expeditiously. We have a kind of checklist that we want to see in the JMR, but I don't draft the first version. Maybe one day I should.
Yeah. So will you share your checklist?
Sure.
Great.
Sure.
All right, so that'll be part of our program materials, and now we will go to the next part of the boot camp. Thank you so much, Judy, and your wonderful students.
Thank you. Thank you, students.
Yeah, thanks, Judy and students. What a great group. I feel like we need a cheer track or something, because I feel like that would be happening at the end of all of these panels if we had that, but we don't. Right now, we are going to take a quick break so you all can grab something to eat. And please do come back and join us in 4 minutes. And we will transition into the clinic student panel. And I'm really excited to hear from all these students about their experiences in a clinic serving veterans. So see you in a few minutes.